All right, federal judge did something that has not happened in modern Department of Justice history. Not one attorney, not two. The entire litigation team was removed. Every single lawyer that Attorney General Pam Bondi had assembled and deployed across 23 federal cases was disqualified in one order. That's $127 million in active litigation. Now on hold, 14 cases suspended, and the government has just 72 hours to replace them all or show up in court with no one at the table. I've been going through this 47-page order since it dropped. Some pages I read twice. And I want to break down exactly what it says, what it means, and why Thursday could be one of the most important days for this administration's legal strategy. Let's start with the deadline. The judge gave the Department of Justice 72 hours. No extensions, no appeal window before compliance. Immediate effect. That's not normal procedure. That's a judge who has made up his mind and wants action now. Quick context. Attorney General Pam Bondi moved quickly after her confirmation to build a strong litigation team. That team became the government's main force in some of the biggest cases currently in federal court. A major tech antitrust case, a defense contractor fraud prosecution involving 41 individuals, and a civil rights enforcement action that had been developing for 2 years. These were serious, high-stakes matters. The problem didn't start on Monday. According to the court order, the issues began back in September 2025. The department's own Office of Professional Responsibility, the Internal Ethics Office, issued 4 separate written warnings over 5 months. Each memo raised concerns about specific attorneys and their connections to a private law firm. The warnings grew stronger each time. The first memo recommended against one appointment. Later memos warned of possible judicial intervention. By February 2026, the Ethics Office wrote that they had done everything they could internally, and the risk was now documented. The judge cited all 4 memos in his order. He noted that the government cannot claim surprise when its own compliance office had repeatedly flagged the issues in writing. At the center of the ruling is a conflict of interest. The court found that the government's lead counsel maintained financial ties to a private law firm while overseeing federal cases. The order states that the attorney had an active financial relationship with a firm that had represented interests adverse to the government's position in the litigation. The judge documented 7 specific instances where case strategy discussions occurred close in time to financial transactions involving the connected firm. The court concluded this created an actual conflict, not just an appearance of one. Because of that finding, the judge disqualified the entire litigation team across all 23 cases, rather than removing individuals one by one. The impact is immediate and widespread. The major tech antitrust case, worth $89 million in active litigation, saw its defendant company's stock move noticeably within hours of the order. The defense contractor case involves 41 individual defendants, whose futures are now on hold. And the civil rights case, 2 years in the making, has victims and witnesses waiting while the government finds new counsel who can pass the judge's review. The judge made clear that any replacement attorneys will face heightened scrutiny. He is not going to simply approve whoever the department sends. He has already signaled he will look closely at any new team. Now let's talk about the timeline, because the pattern matters. Between November 2025 and March 2026, 3 attorneys connected to the same firm network joined the DOJ litigation team, even as the internal ethics warnings were escalating. The order traces this hiring pattern in detail. Defense attorneys in one of the cases had raised concerns earlier in January and February. They requested conflict disclosures and later filed under seal, asking the court to review the issue. The judge ultimately agreed with their concerns after reviewing extensive evidence, including depositions, emails, and financial records. The Department of Justice has already filed an emergency motion asking the appeals court for a stay. Their argument focuses on the scope of the remedy and the operational impact on ongoing cases. What they have not done, at least so far, is directly challenge the factual findings about the conflict itself. Legal experts I've spoken with, including former prosecutors and ethics professors, say this ruling is unusual in its scope. Some note that the standard the judge applied is stricter than what some other courts might require. Others point out that the 72-hour deadline is aggressive but understandable given the court's findings. On the other side, administration defenders argue that the attorneys followed the formal disclosure rules and that waiting periods were observed. They also note that defense lawyers raised the issue close to important deadlines in several cases. The judge acknowledged the timing but ruled that it does not erase the underlying conflict. What happens next is critical. Thursday at 10 a.m. is the replacement deadline. Immediately after, there will be a status hearing. The judge has also left the door open for supplemental remedies, which could include sanctions or other measures. He has not yet decided on possible bar discipline referrals. That remains pending. If the appeals court grants a stay before Thursday, the current team could stay in place while the legal fight continues on a normal timeline. If no stay is granted, the department will have to present new counsel under very close review. Beyond these specific cases, this ruling could have wider effects. Defense attorneys across the country are already studying the order. It sets a clearer and stricter standard for attorneys moving from private practice into government service. The revolving door between law firms and the Department of Justice just became more complicated. For everyday people, the impact is real too. In the civil rights case, victims who have waited 2 years for their day in court are now waiting for the government to assemble a new legal team. In the defense contractor case, subcontractors and supply chains are feeling the ripple effects of the delay. This is not the end of the story. The cases will eventually get new lawyers and move forward. Some will settle, some will go to trial. But the order itself, with its detailed findings and 340 pages of supporting exhibits, will remain part of the legal record. Future judges and lawyers will cite it when similar conflict questions arise. Thursday's hearing will tell us a lot. Will new counsel be approved? Will the judge impose additional remedies? Will the appeals court step in? We'll know soon. For now, the message from the court is clear. When it comes to conflicts of interest in high-stakes federal litigation, the rules matter, and documented internal warnings cannot be ignored. I'll be following every development closely. When the appeals court rules, when new counsel is named, and when Thursday's hearing happens, I'll break it all down for you. If you found this breakdown helpful, hit subscribe and turn on notifications. This story is moving fast, and I'll have the latest updates as soon as they drop. Thanks for watching.